So now let's take a look at another decision from Munich, from the same court, from the District Court of Munich. Here, in a case between Huawei and AVM, as the defendant. AVM is a German company which is based in Berlin, and it manufactures routers, etc. Here again, we have a Wi-Fi 6 patent asserted. This decision was delivered in November 2023, some while ago, but it was published very late, and that's why we are only just talking about this now. But nevertheless, I think it has some interesting findings as well, and it's worth taking a look at. Again, we have not the full chronology of facts here because we had reductions in the decision. What we can see is that the proceedings started in March 2022. Huawei filed an action against AVM in Munich, and the decision was delivered in November 2023, so almost 1.5 years after that. And that led at some point in time, some months later, in April 2024, to a settlement. So Huawei and AVM have announced publicly that they have settled. So this means that these proceedings will not likely anymore lead to a decision from a higher district court. So this is more or less, I think, the final decision in this dispute here. Nevertheless, the court touched upon many interesting aspects as well, and we're going to go quickly through them. The court had some thoughts also on the notification of infringement in this case. Again, there is the need to make a notification before you file a case, and here the court found that at the end of the day there was a sufficient notification of infringement. Again, the court found that the court action filed here was a sufficient notification itself. And what was interesting here is that the court did not look at the claims particularly that have been asserted here. So if you had the injunctive relief asserted at a later point in time in the proceedings, or initially you didn't have injunctive relief in the claims that you asserted, but it looked at factually how this case developed. And there were two actions filed here before by Huawei against AVM in Munich, and the other trial, they were both running in parallel, and the other trial was prioritized. So they discussed, they worked on the other trial, had hearings, etc. But this one here was factually stayed. So the other proceedings parallel were prioritized. This one was stayed, and the fact that you had this time after the action was filed until the court actually started looking at the case here, and deadlines started running, and hearings were held, etc., was sufficient for the court to say that you had, through the action that was filed before court, the sufficient notification of infringement, because you had some period in time to look at the information that was included in the court action and make up your mind before the trial actually started gaining traction. So I think an interesting argument here by the court regarding the notification of infringement. The court also said that prior trial you had not required a notification here because AVM was unwilling. So the court made this link here and saying that when the implementer is unwilling, then the notification is a mere formality. So it shouldn't stand in the way of court proceedings and the potential injunction. So again, a very flexible view taken by the court here when it comes to the notification of infringement and when notification, when the information required has been sufficiently provided to the implementer. Here in these proceedings, what was interesting was that the court looked at the behavior of Huawei before more or less going much into the willingness discussion. This is interesting because, as we have said already, we have the Huawei ZTE judgment, which starts with a notification of infringement and then looks at the implementer who received this notification, whether he has been willing or not. So here, the court looked at Huawei's behavior first, and under a specific angle, we're going to talk more about that in a moment. But it did that for one specific reason, and we mentioned that already. The behavior of the patent owner determines to a certain extent the duties that the implementer has and needs to meet in order to be considered willing. And we said already, if there is an offer, for example, by the patent owner that is absolutely unacceptable, or the behavior of the patent owner in general is absolutely unacceptable, then this forms also the extent of the duties of the implementer. For example, you don't need to respond to an absolutely unacceptable offer. So that's why here the court looked at Huawei's behavior first, and it came to the conclusion that the behavior was not absolutely unacceptable, and the offers that were made to AVM were not arbitrary, but more or less an adequate basis, again, to start negotiations. The consequence of that was that AVM had a duty to react to this license offer and to negotiate in good faith. And the court, as we will see later on, found that AVM failed to do that here. What the court said, and there was a lot of discussion around the amount, the price that was requested here. So the argument was basically that what Huawei requested was far too high. And the court said a high price request by itself does not make an offer arbitrary. So you have to have, in addition, some punitive elements. That's what the court defined this, in order to consider the price request or the conduct in general as absolutely unacceptable. And this is again a threshold that needs to be taken. And because the court said even if you have a higher price requested by the patent owner, it is the task of negotiation to lead the price to an objectively reasonable level. So if there is still a leeway to discuss and negotiate, you cannot just say the price is too high, I'm sitting this out, I'm not engaging in negotiations. This can only happen in cases where you have an absolutely unacceptable offer, but this is again something where the threshold is rather high. It's not the regular case. Having said that, there was a discussion around what the infringement code should do actually here. So how far should the infringement code look at the price? And the court started thinking about that from the angle of what is the front defense actually about. And the court said the front defense basically is based on the argument that there has been a refusal to grant access to the patent. And the court said here we're talking about legal access because factual access is given since the patent can be used without a license. So if the legal access is refused, then you have a front defense basically established. And when do you have a refusal to grant access to the patent? Either when you don't have at all the intention to grant a license, so if you refuse to grant a license anyhow, or if you grant a license to an unreasonably high price. And here the court said this unreasonably high price, which basically bars access to the technology, can also be to a certain extent, at least, or there can be an overlap with a price which is exploitative and excessive in antitrust terms, but it's not necessary. So you could have a high price which basically makes access to the technology unreasonable because you cannot sign a license on these terms. This could be also problematic from a competition law angle. You could have an excessive price, which constitutes an exploitative abuse, which is prohibited under competition law, but it's not necessary. And the court said here to decide the cases with SEPs, the front defense cannot really go so far as to examine which would be the perfect competition law compliant price. you have, and it's sufficient if you look at the comparable licenses and compare this to what the terms that have been offered in the present case, because the terms on which comparable licenses have been granted in the market are capable of granting access. And this is enough when you talk about the front defense. So what the implementer can do is to take a license on these comparable terms, and if he still believes that there is a competition law issue with the price, that the price is excessive and exploitative, then subsequently you can contest the price. But then you would not be going to the infringement courts, but to antitrust agencies or the competent competition courts. And that's something what the court here stressed, that in the context of a front trial, of an infringement trial, these arguments around an exploitative abuse in antitrust terms, excessive pricing, etc., will be part of the proceedings only in extreme cases. So it's not that the court is regularly going to dig so deep here and do this analysis. There is a reason for that, because the court believed that this analysis requires a lot of time and a lot of cost. You will need to have expert opinions. You will need basically much work to see if what is the competition law compliant price. And this, in the eyes of the court, can, in infringement proceedings, create an imbalance to the detriment of the patent owner. Why? Because as long as this question has not been clarified and the proceedings are still pending, the implementer factually gets a free license. And what is more, these delays in the infringement proceedings are very problematic in the eyes of the court, because you have, first of all, in the cutting edge technology sector, very limited life cycle of the technology. So you need to have fast decisions. And of course, when you deal with patents, you have a patent term. So the patents expire at some point in time. So let's say bringing all of this weight in the infringement trial can be can create an imbalance to the detriment of the patent owner, because it would cause delay and more cost. And the court went even a step further here to say that if you have an implementer that makes a request to deal with all of these very specific and very complex issues in an infringement trial, this request could be abusive. And this means that if you file such a request, and this can be, it's very likely that you will cause further delay in the proceedings, especially after years of negotiation. The court should regularly dismiss these requests. So the assessment here, the analysis should more or less look at the comparables, and everything exceeding that, going deep into the competition law, the issues that might arise with that, is usually not the right thing to do, especially the infringement courts, the patent courts are not the right place to do that. So I think that's maybe summarizing a bit the views that the court expressed here. Then there was also some discussion about whether the terms that Huawei offered were discriminatory. The court said they were not. What is discrimination is, in the eyes of the court, treating same cases differently or different cases equally. And in the front context here, you would have discrimination when a similarly situated licensee got preferential conditions to a non-negligible extent. So again, here, per se, the fact that you would have different conditions is not sufficient to establish discrimination. You have to go above a specific threshold, and the court defined this here as a non-negligible extent, meaning vice versa, that if you have an insignificant different treatment that can be resolved through negotiation, the implementer should still try to reach agreement, so should still negotiate. It's not an excuse, again, to say that I got different terms than the others, and I don't want to negotiate further. One interesting aspect here also is that the court said, well, if you argue that your competitors have gotten a better price or have gotten better conditions, then to be seen as willing and acting in good faith, you must be, as an implementer, prepared to take a license on the same conditions, which are allegedly better, and not only be prepared to do that, but objectively demonstrate that you're prepared to do that. So here the court added that this argument that the others got a better deal can basically be heard only if you are at least prepared to take a license on the same terms. If not, then this is something that might be considered in the assessment of the implementer's behavior regarding willingness, for example. And this is what happened here. So the court generally found that AVM was not willing to obtain a license. The court, again, we don't have the details. The court looked, however, at the overall behavior of AVM, but we don't have a full chronology, again, as I said before. But generally, the conclusion of the court was that AVM did neither negotiate in a target-oriented manner nor engaged constructively in the discussions. And the court mentioned, for example, the reaction to the notification of infringement that was not seen sufficient because, as far as we can understand from the text of the decision, AVM basically referred to a statement that it had posted in its website, and the court found that this was not a sufficient response or notification of infringement because it does not address a specific portfolio. It's a general statement. And what the court also saw here is that AVM's behavior during the proceedings were also not really indicating that it's willing to take a license. So it looked on both before and during the trial how AVM behaved, and in general found that this was not enough, it was not sufficient. There were two last points which I think are noteworthy from this judgment here. And the one is the fact that to a certain extent, the court examined also a contractual counterclaim that AVM filed here. What do we mean by that? Apparently, at a later stage of the trial, AVM tried to argue also against the injunction based on the letter of assurance that Huawei has given towards IEEE concerning the specific patent that was asserted here. So here, basically, the argument was, apart from the main competition law arguments that we have seen before in supporting the front defense that AVM had raised here, it was to say basically that the IEEE LOA of Huawei gives a claim to be granted a license, and this claim should exclude an injunction because, on the one hand, it excludes infringement. So this was apparently the way the argument went. And even if it didn't do so, then it was definitely, let's say, a bad faith behavior on the side of Huawei to try to grant an injunction while at the same time being obliged to grant a license on the same patent. Now, the court dismissed that argument here. It did not examine in every detail whether there is indeed a claim to be granted a license under the IEEE LOA, but it said even if you assume that this is the case, so even if you think that the IEEE LOA grants the implementer with such a claim, this does not change anything in the unlawfulness of AVM's behavior. Why? Because even if there is a claim to be granted a license, there is no license formed, because all key terms are open, so nothing has been agreed upon. And other than that, you cannot really extract a right of use or a permission to use out of the IEEE LOA. So on the one hand, there is not sufficient ground to say that there is no infringement because in some way I have a right to use the patent under the IEEE LOA. Apart from that, the court also found that this argument that you should not grant an injunction here because you have this counterclaim was not very convincing. This is called a dolo agit defense. This is back to Roman law, and it's a principle which goes. It's a principle of civil law, so it's not a patent law or a SEP related principle. What is meant by that is basically that you cannot claim something that you would need to return based on a counterclaim directly. So in our case, you cannot claim an injunction, basically preventing someone from using the patent if you need to grant a license to the same patent allowing such use. The court dismissed that argument basically because it said that AVM cannot raise this because it acted in bad faith and it did not take all steps required for a timely conclusion of a license. So that's here the reaction of the court to this argument, saying basically even if you would assume that all of this would have some merits, AVM acted in bad faith here, so that the court cannot consider that. And apart from that, this was a defense that was raised at a very late stage of the proceedings. Finally, the court also had to deal with an additional defense that AVM had raised here, and this is the defense regarding proportionality. So here the argument is to say that granting the injunction based on this one specific patent would cause disproportionate harm to the implementer, which goes far away from the actual value of the patent and the technology that it has incorporated. And the court dismissed that as well here by saying that this is something that applies in exceptional situations, and such situations were not given here. At least AVM did not manage to show these circumstances, these exceptional circumstances here. Again, in Germany, an injunction is the regular sanction against patent infringement. So if you argue with proportionality, you have, let's say, an uphill battle that you need to show facts that can establish that. And the court said, actually arguing that in SEP cases like this one, the injunction serves only the preservation of the monetization claim, meaning that the patent owner does not actually need to protect its own products in the against the competition, but it's just looking to get money out of its patents, does not make an injunction disproportionate, as long as the parties can reasonably negotiate the rate. And this was the case here. And the court mentioned that AVM had the opportunity to legitimize its infringing acts, but did not do that. And if you are an unwilling licensee, willingness being a factor that should be considered when it comes to proportionality and the assessment of whether to grant an injunction or not. So if you're unwilling, then an enforcement of the patent is a logical consequence. So this is something that you could expect. The final element here, just to keep in mind, is that generally the court said that in FRAND cases, a proportionality defense will not be available when the patent owner has met its FRAND duties and there are no further circumstances establishing this proportionality. And this is in line with the case law of the Munich court for a while now, which basically sees a very limited or maybe not existing leeway to have also proportionality on top of a FRAND defense in SEP cases. Because if you have the possibility to argue a FRAND defense and you can make this type of arguments, it's very unlikely in the eyes of the court that proportionality will play a role on top of a FRAND defense. So this decision here is more or less also in line with what we have seen from the Munich courts so far regarding the proportionality issues when it comes to SEPs and FRAND committed patents.